Good afternoon and welcome to the third 1L Convocation lecture in the lecture series this year. My name is Keith Bybee, professor at the College of Law and the Maxwell School. And as you know, Dean Arterian and I organized this lecture with an eye towards speakers and topics that'll be of general interest to the university community and of particular interest and value to the 1L class. And today we are very fortunate indeed to have found time in the very busy schedule of one of the most distinguished members of the faculty administration here at Syracuse University to address us. His name is James Steinberg, and he is Dean of the Maxwell School and also University Professor of Social Science, International Affairs, and Law here at Syracuse. The title of his lecture today is Law, National Security, and Public Policy. What have we learned since 9/11? Prior to becoming Dean in July of 2011, Dean Steinberg was Deputy Secretary of State, serving as a Principal Deputy to Secretary Clinton. From 2005 to 2008, he was Dean of the Lyndon B. Johnson School of Public Affairs at the University of Texas. And previously, he was Vice President and Director of Foreign Policy Studies at the Brookings Institution, where he supervised a wide-ranging research program on U.S. foreign policy. He has served as Deputy National Security Advisor to President Clinton, and that was from 1996 to 2000. During that period, he also served as the President's personal representative to the 1998 and 1999 G8 summits, back when it was G8. Dean Steinberg has been Director of the State Department's Policy Planning Staff and Deputy Assistant Secretary for Analysis in the Bureau of Intelligence and Research. He was Senator Kennedy's principal aide for the Senate Armed Services Committee and Minority Counsel for the U.S. Senate Labor and Human Resources Committee. What else does he do? He writes books, and his most recent book is entitled Difficult Transitions, Foreign Policy Troubles at the Outset of Presidential Power, co-author with Kurt Campbell. Dean Steinberg, I think as you can see from just this brief summary of his many achievements, has accomplished a great deal. He has traveled very widely and has worked for many years at the highest levels of policymaking. And I imagine he has learned how to cope with jet lag during this distinguished career. Before I turn the podium over to Dean Steinberg, I just want to remind you of a few points of protocol. Please make sure that all of your mobile devices are turned off. So anything that can beep or ring, please ensure that it's shut down. After Dean Steinberg is done speaking, there'll be an opportunity for Q&A. If you have a question, please just raise your hand, and we will approach you with a wireless microphone. Please wait until you have the microphone to give your question so that everybody can hear it. Finally, we will make sure and to conclude the lecture today to give you time to get to your 1 o'clock class. Without further ado, please join me in welcoming Dean Steinberg.
Thanks, Keith, and thanks, Dean Arterian, for inviting me to be here today. I, too, once was a 1L, and I remember fondly what it was like. If this were a concert, you'd all be clamoring to sit in the center orchestra, so let me just encourage those of you on the sides to come in and fill in here. It's really okay. I'm not going to call on you, and you'll probably hear a little better, so please take advantage of this if you would. The title of my talk is about the lessons that we've learned from 9/11, but I actually, thanks guys, I do appreciate it. Why don't the rest of you come on in? It's just, you can see better, you can hear better, and I don't bite. The title is Lessons Learned from 9/11, but I actually want to start in thinking about the lessons learned from 9/11 by going back to one of my own experiences that actually predates 9/11. When I graduated from law school, I spent a year, I did a clerkship, like some of you will do, and then after I finished that clerkship, I had a tremendous opportunity to begin my career in public service by working as a special assistant in the U.S. Justice Department. And I got there in the summer of 1979 with a background mostly working on domestic political issues, healthcare, urban transportation, and the like. But as a special assistant, I had a fairly wide-ranging portfolio working for the Assistant Attorney General for the Civil Division. And I happened to be in the office on a Sunday morning, November 4th, 1979, which is when special assistants and not their bosses are often in the office, when the Assistant Attorney General's special phone rang, the phone that was the hotline from the Attorney General's office to all the other principals in the department. And as she was not there, I picked up the phone. I said, Mr. Attorney General, Ms. Daniels is not here. Can I help you? And he said, yes, well, we have a small problem. I wonder if you could come up to my office. And that small problem, of course, was that on that date, 52 Americans were taken hostage by the Iranians at our mission in Tehran. And over the next year and a half, I spent most of my time at the Justice Department working on the problem of the Iranian hostages. And it was a very multidimensional problem, as you know. It involved different kinds of lawyering skills, including working as part of the team that backed up then Deputy Secretary of State Warren Christopher, who was doing the negotiations for the release of the hostages. It included working on a very complex and elaborate set of issues around claims against Iranian assets in the United States by individuals and firms who had claims on those assets. But there was one piece of this that people who read the story of it don't know as well, but is very relevant to the discussion we're going to have today. Because one aspect of that had to do with the question of public demonstrations by Iranian students in support of the hostage takers in Tehran. Because there were a large number of Iranian students in America at that time, and many of them were quite opposed to the regime, the previous regime in Iran, the Shah of Iran, because of his repressive policies. And so when the revolution took place, that many Iranian students were very favorably disposed. And after the hostages were taken, they indicated a desire to demonstrate in favor of the hostage takers and to indicate their support for the revolutionary government in Tehran. As you can recall, and I know it's before all your time, this was an extremely volatile time in the American public. The American people were angered, incensed about the hostage taking. And the pressure on the President of the United States to do something about that and to get the hostages out was, of course, fairly intense. And so in the early days after the hostage taking, as I said, which took place on November 4th, a number of groups, both those opposed to the hostage taking who wanted to show their support for the Americans held captive, and students who wanted to support the hostage takers, applied for permits to demonstrate in Lafayette Park, the nation's living room, the park right in front of the White House, the place where, during our history, the most important public demonstrations and the exercise of the right to petition our government has taken place. Because I was part of this team that the Attorney General had assembled to work on the problem, we were asked what should be done about this, because we knew that there would be a lot of pressure and a lot of anger at the sight of Iranians demonstrating in front of these people who'd violated international law. And working with the team, we sat down and worked with the Attorney General, who, after a week of deliberation, sent a memorandum to the President of the United States. And in that memorandum, then Attorney General Benjamin Civiletti wrote to the President, "It's my firm opinion that we cannot legally deny the right to persons, Iranian or American, who do not have some provable record of violence themselves, to demonstrate on federal properties in Washington in support of or in opposition to the United States policy in Iran." That memo went to the President, and the President wrote back in his own hand on that memo, and these are his words, "I strongly prefer that we do our best to prevent permits being issued for pro or anti-Iranians until hostages are freed. Take our case to court if necessary." Now, you can imagine this came back, and as young lawyers, this posed a real challenge. On the one hand, the Attorney General giving his opinion as the chief law enforcement officer of the United States, that it would be, he used the word, cannot legally deny, but implicit in that, of course, was that we cannot constitutionally deny the right of these to take place. And the President basically telling him, not ordering him, but saying, "I strongly prefer." And when presidents say they strongly prefer, you get the message, right? So on the basis of that, the Attorney General wrote back to the President, "I share deeply revulsion at the views of students or anyone here supporting the vicious acts of terrorism against our people in Tehran. I pray for your strength and their freedom." And then he proceeded to give advice to the Secretary of the Interior, who was in charge of Lafayette Park, to deny the permits. Most of us in the Justice Department at that time, having been working with the Attorney General on his initial opinion, were quite confident we were going to lose that case, and we knew we would be sued by those who wanted to hold those demonstrations. But we decided, and it's an interesting question of ethics, which you all can debate, that even though it went against our best legal judgment, that we would defend this case in court, as the President requested. And we went to court, and we won the case in the district court. District court upheld the denial of the permit, and predictably it was appealed to the court that I had just finished clerking for, the DC Circuit. And we saw that morning as the panels, which are randomly assigned, came up, and on the panel were 3 judges, as there are in appellate cases, and 2 of the 3 were among the most liberal judges on the DC Circuit at that time, Chief Justice Skelly Wright, Judge Harold Leventhal, and 1 more conservative judge. And so, although we're not supposed to pay attention to who's on the panel, it seemed to us even more certain, given our own judgments about the law, that this decision would be reversed and the permits would be reinstated. Just a few hours after the oral argument, we received a notice from the Court of the Clerks saying that an opinion was about to come out. And shortly thereafter, a 1-paragraph opinion came out, issued per curiam, which, if you haven't come across that yet, is an unsigned opinion, and which, under the direction of the court, was determined to be a per curiam opinion which should not be treated as precedent. And in that per curiam opinion, Jackalone versus Andrews, don't look it up because it's not in your books, because it is non-precedential, the court upheld the denial of the refusal to give the permit. And the court said, in its unsigned opinion, "We accept the representation of the State Department that a demonstration at Lafayette Park has an unacceptable potential for danger to the hostages now being held in the American Embassy in Tehran." End of the case. So why do I raise this now in talking to you about law, public policy, and post-9/11? Because I think what it illustrates in many ways is so many of the dilemmas that both lawyers and public policy makers face in dealing with challenges of national security. On the one hand, we are a country of laws and a country of principles. Principles of limited government, limited both in terms of the roles of different institutions, the executive branch, et cetera, and limited in the role of the government vis-a-vis individual rights. And yet, in times of crisis, the institutions adapt to the challenges of their time. And as you saw here in 2 instances, both the President, in effect, being his own lawyer and asking the Attorney General to go to court to defend an action which the Attorney General himself had doubts about its legality. And then a court, which by most of its precedents probably would have a hard time justifying why this permit was denied, felt under the circumstances that rather than take on the public wrath and the opposition of the President, decided, in effect, to punt. Now, this is, I think, useful as we begin to think about the 9/11 environment, because in many ways, 9/11 is a much more dramatic posing of the challenges that lawyers and the legal system face in trying to deal with intense national security problems. Indeed, as was the case for President Carter, who after all was responsible for the lives of those hostages, the primary imperative, the single most important imperative that any president faces, is, of course, protecting the lives and safety of Americans. And so this has to be paramount in their mind at all times. And at the same time, they came into office and they put their hand on the family Bible and promised to faithfully uphold the Constitution and laws of the United States. But why is this such a big problem? For the social scientists among you, the problem can be described as the problem of what we call type 1 and type 2 errors, or false positives and false negatives. For the legal system, the system that you're studying, in which our constitutional laws are embedded, and especially the criminal law system, we are very concerned and very worried about false positives, accusing somebody, depriving them of liberty or their rights without demonstrating that there is a compelling case for doing so. And so we have a system that tends to err against making those mistakes, against falsely accusing somebody. We have all kinds of protections, evidentiary protections, protections against the way information is used, the requirements of a high evidentiary standard, proof beyond a reasonable doubt in our criminal justice system to make sure that the innocent don't become punished. And we take the risk in those circumstances that sometimes the guilty will get away. And we believe, because of the other values in our system, that that's a better balance of the choices. But imagine that you're President of the United States, and you're facing the possibility that this type 1 error, letting the guilty go away, means letting somebody escape or get away or be free who's determined to commit mass atrocities against the American people. How do you feel about that balance? How do you understand your responsibility and the balance between a false positive and a false negative? And so you can imagine on September 10th, sitting in the White House, September 10th, 2001, how President Bush and his team felt about what their responsibilities were after arguably the worst attack on the American homeland, and whether and how much they could tolerate a system that would have many type 1 errors and take the risk of having innocent people held or actions taken against them, as against the risk that people who were determined to do harm would be able to be free to do so. And behind that, of course, illustrates the very different imperatives between a criminal law system, a criminal justice system, which focuses on individual culpability and largely on punishment after the fact, rather than preventing bad things from happening. And again, you can understand the theory why we should have a system that focuses on culpability, the idea that you should only have your liberty deprived, things taken away from you, if you have a sense of responsibility. That's why we don't hold people who are children criminally responsible. That's why we don't hold people who don't have the mental capacity to judge right from wrong guilty, even though they committed the act in question. And yet that model of culpability, of punishment after the fact, doesn't really apply very much in the context of the responsibility of a president or a secretary of state or a secretary of defense who have these duties of protecting people. Their job is to prevent bad things from happening. And if they have failed to prevent them, then they failed at its task. Now, it's true the criminal justice system has an element of prevention. We call it deterrence, the idea that people knowing that they'll get punished and that there's a probability that they'll get caught will deter them from doing this. And we also take some efforts when we see that that the system is not being effective in prevention to change the way we do punishment. So we have repeat offender statutes that say if you commit a lot of crimes, we're going to be a little less lenient with you. We're going to throw the book at you. We're going to keep you away. In the jargon, that's known as incapacitation. We're going to lock you up so you can't do it again. And that has an element of prevention, too, in the individual case. But that's not the focus of what the criminal justice system does. And therefore, what you saw in the post-9/11 environment was a quick turn away from dealing with the challenges of terrorism as primarily a problem of the criminal justice system, because it was felt by the people who were responsible for national security that this criminal justice system, not that it was flawed in its own terms, but it simply was unresponsive to the problem of prevention. And that's generally true in national security, but it's especially true with respect to terrorists for two reasons. One, because to the extent that there is any prevention in the criminal justice system, it's because of its element of deterrence, the idea that you will be punished and locked up. But for the terrorist, the idea that they would be punished and locked up is hardly a deterrent when the impetus to the act of terror is a much higher one. And indeed, in many ways, the prospect of being locked up is simply another act of martyrdom. And so the deterrence feature, not very powerful in the terrorist context, and even worse, as the new administration began to contemplate the idea that terrorists might actually become linked with weapons of mass destruction, nuclear weapons, chemical weapons, biological weapons, the cost of failing at prevention were enormous, even greater than the terrible tragedy that was experienced on 9/11. And so you saw for 4 or 5 years the playing out of this deep tension between a criminal justice system designed to achieve a certain set of objectives, and a national security establishment led by the president, the vice president, and his team that were focused on doing everything they can to prevent acts from happening. You saw this on surveillance policy. Under what circumstances should the United States, the federal government, be allowed to listen in on phone conversations, to participate in meetings in churches and mosques, to follow people, to read their emails? You saw this on detention policy. Under what circumstances should the federal government be able to lock someone up without bringing them to trial, without them being convicted of an Article III defense? You saw this, and we see this even today, in this long debate about targeting and the use of drones and other lethal techniques against individuals who had never been convicted of a crime and yet were subject to the ultimate sanction. You saw this in the use of cyber tools in which intrusions were made into websites and other arguably protected First Amendment activity to try to prevent terrorist or other dangerous activities. And so each time when the challenge came of the question of do we use a model of prevention or do we use the criminal justice system, the administration chose consistently to favor that argument for prevention. Now again, some of these tools are not entirely unknown to the criminal justice system. We have, for example, the law of criminal conspiracy, which allows you to lock somebody up even before the crime is committed if they do something that's in aid of, in support of a conspiracy, even if that conspiracy never ripens into an actual criminal act. You also have parallels in our mental health system in which we allow people to be held, to be detained, as it were, even though they haven't done anything wrong because they pose a threat to their own safety or the safety of others. So we do have elements in our traditional legal system, but few of them really responded to the imperative of the time, which is the tools that are needed to prevent these acts from happening. And in parallel to this shift from a criminal justice mindset or paradigm came also a focus on who in the structure of the federal government should have the responsibility for making these decisions. After all, at the end of the day, although the executive branch, as it were, is the branch that investigates crimes and brings criminal prosecutions, it is the courts that have the final say, courts along with juries, the criminal justice system, as to whether somebody should have their liberty deprived under the criminal justice system. But clearly, in the thinking of those in office after 9/11, that model of leaving it to the judges to decide when action was justified was simply not going to meet the imperatives of our time for two powerful reasons in their judgment. One, because the need to act swiftly was overwhelming, that you would get information, there'd be ticking time bombs, you'd need to be able to act without going through a judicial process, and also because of the imperative of secrecy. The information that we had was so sensitive, the need to protect sources and methods, that going through the judicial system would imperil the sources and methods and our ability to prosecute that war. And so in parallel with this focus and the shift in focus to the prevention paradigm, we saw an increased emphasis on the roles, responsibility, and authority of the executive branch to make the decisions that were necessary to protect security, and a strong argument that neither the Congress nor the courts should have a say in this matter, that these were issues of national security that were entrusted to the Commander-in-Chief under Article 2 of our Constitution, and that he should have the sole right to make these decisions unsupervised by or overseen by either of the other two branches. Now, of course, since the heyday of that movement, both towards the prevention paradigm and to the focus on the executive, we've seen that there's been a shift of the pendulum back. The courts have intervened and said that on a number of these issues that they do not accept the fact that these decisions should be taken out of the responsibility of the courts, whether it's on detention, whether it's on the right of habeas corpus, which is the right to have the question examined by judges. The courts have consistently said that they don't buy this extreme version of the imperative, that the executive needs to be able to act to prevent. And similarly, with respect to the role of Congress, we've seen Congress, in effect, supported by the courts on issues like surveillance, being given a more active role in trying to define under what circumstances the administration should be allowed to intercept communications from Americans, even from outside the United States. Pushed back to the Congress the question of whether we should have military tribunals rather than criminal courts to try people accused of being involved in terrorist activities. And so the court said that the president himself could not set up these tribunals. He needed a statutory basis to do it. And so we've seen over time, despite the very strong imperative that we saw back in my case, of courts being sensitive to the dangers of judicial intrusion in these very sensitive matters of national security and life and death for Americans, that over time, as the immediacy of the tragedy of 9/11 has moved away, so has some of the more traditional concerns. But there we've seen, of course, the lawyers coming into play in the judicial system. But the question is, where were the lawyers in the executive branch when all this was going on? And what were their responsibilities under these circumstances? Going back to the question of the role that Attorney General Civiletti played back when I was first in the Justice Department. Now, of course, you've already begun to think about this, and I'm sure you're talking about it in your classes. There are many ways to think about the role of the lawyer, but the role of the lawyer in the government is a very special one, because of course he is or she is the lawyer for their client, whether it's the president or the head of an executive agency. And of course, like all lawyers, they're also an officer of the court, and that imposes certain responsibilities and certain ethical responsibilities on how they uphold this responsibility to advocate for their client. They can't lie, they can't steal, they can't cheat, even though that might, in some sense, serve the interests of the client. But the lawyers for the government have a set of other considerations which the lawyers in private practice don't face. First of all, they too, like the President of the United States, put their hands on the Bible when they take the job, and they've agreed to faithfully defend the Constitution and the laws of the United States. And so they have a separate obligation than their obligation to defend the interests of their clients. And when it comes to the Attorney General in that sense is not just the President's lawyer, but he's the nation's lawyer, and has a responsibility to a client which is a much less well-defined but a broader set of public interests. And so as these jobs are taken on, how does the public lawyer, the government lawyer, think about this? Having a responsibility and understanding the client's responsibility, not in a venal sense, to protect the security of the people, but rather one which is genuinely motivated, as President Carter was genuinely motivated in the case of the hostages, not to see harm come done, and yet to balance all of those things that come together. Well, from my own experience, and I've been in government for a long time, but only briefly as a lawyer, I think there are several things that lawyers can and do when they're dealing with these difficult national security problems. The most important thing that they do is that they help their clients, the president, the senior officers of the government, understand the legal dimensions of the problem, understand where law is relevant to their considerations, whether it's laws involving civil liberties, whether it's laws involving the responsibilities or rights of the executive branch vis-a-vis Congress, whether it's the laws of the international law, in the case of national security, the law of war, or laws of armed conflict. They're able to explain to their client, the President, the Secretary of State, the Secretary of Defense, what are the dimensions, what are the factors that you need to think about? How do we think about the decision, for example, to use force against an individual outside the United States who has never been convicted of a crime? What do we think about this in terms of the understandings we have from the law of armed conflict about necessity? Is it really necessary? Are there other things that might be done to deal with this challenge? The law of proportionality, is this proportional to the harm that's being posed? The concerns about collateral damage, is this going to be done in a way that doesn't harm innocent individuals? And by illuminating those considerations, the lawyers are often not in the position to say what the answer is. They're certainly not the ones who are best judged as to whether a particular action is necessary for national security, whether it's likely to have collateral consequences on innocent people, but at least they can force the client, the public official, to think about those things and to explain how they process that in a way that allows them to be able to make the case and to be able to defend the proposition that they were acting consistent with law. So that's one thing. They do help illuminate the considerations that are at stake. The second thing they do is they do help the president, the other officials, understand what might happen if these actions get taken to court. And as you can see from the case that I was involved in, the lawyers aren't always right about those things. But it is an important consideration, both a legal and a political one, for a president or a cabinet official to know what is likely to happen or what the lawyers think might happen if they go to court and be able to take that into account. It's not absolute requirement that they are certain that the client will prevail, but it's important for the client to know if they think it's unlikely to prevail. But perhaps most important, and one that you might not have thought of, is that one of the things that the lawyers do, and in my experience do very effectively, is help the client think about what the precedential consequences are of a decision. If you decide in these cases that it's legal to use targeted killing, what will the world look like when other people want to follow that precedent? Future administrations here in the United States, other governments who will point to the United States and say, well, you thought it was lawful for you, why isn't it lawful for us? This idea of trying to understand the consequences of establishing a principle of law that governs a set of circumstances is something lawyers can do well. It doesn't put them in a position of judging whether it's a good idea or not to have that precedent, but it does help people recognize that decisions you take now in the exigencies of the moment will have consequences far beyond that moment. And indeed, that is the challenge of all crises, is to recognize that you can make a cost-benefit analysis in the near term about actions, but you'll have to live with those decisions in the long term. And I think that that's one of the lessons that we've learned, and one of the reasons why the pendulum has shifted back from that extreme model that we saw in the immediate aftermath of 9/11, that model that focused on prevention and on executive authority, is because I think there's been a recognition that both, not just as a matter of law, but also as a matter of public policy, that in the long run, even though we take greater risks by going to some of our old traditional values embedded in the criminal justice system, of individual responsibility, of making judgments based on culpability, of protecting basic individual values and principles embodied in the Bill of Rights, that actually in the long run we're better off because we want to live in a world that doesn't have the precedent that those things can be taken away in an emergency. We've had a lot of experiences with emergencies in the history of this country, going back to the founding era and the Alien Sedition Acts, to the Civil War and the suspension of habeas corpus during the Civil War, to the internment of the Japanese during World War II. Every one of those times, the imperative of the moment led the executive branch to look to see what it could do. Some cases, the lawyers gave them comfort. Some cases, the lawyers counseled them otherwise. But what we've seen is we've been at our best, and our strength has been when law and public policy come together, when we recognize that torture is not only a problem under the Geneva Conventions, but it actually isn't good for our ability to get truthful information out of terrorists that we hold, or our ability to make sure that others don't torture our soldiers or our individuals if they get taken abroad. And so this tension that we've seen throughout our history, and that I saw back when I served in the Justice Department, is one that's hard to resolve in the individual case, but I think easier to resolve when you keep the picture of the long term. So I hope as you begin to think about these problems and in your own career, that you'll keep that in mind, that we have to deal with problems in the here and now, but we have to live with them in the long and future. So thanks for your attention, and I look forward to your questions and comments.
Hi. First of all, thank you. I have a question that's got 2 points to it. First, I think that a major problem in national security law, well, specifically the way people understand it, is that there's confusion with terrorism. People seem to think terrorism is an ideology, that there's something clear that our government is trying to prevent, rather than seeing it as a tactic of war that could come from one psychopath in a movie theater or a state like in the Lockerbie bombings. So I wonder, how do you incorporate that notion into our understanding of how the law should work? And also, it seems that the second point, throughout the history of especially humanitarian law, our international law deals with state-to-state interactions rather than addressing state to individual, whether going after a specific terrorist, how is that defined legally? There seems to be a vacuum there. So I wonder if you could address those issues, please.
Thanks. So they're great questions, and they're big questions. So let me just sketch out a few points on this, and happy to have a longer conversation. I think the point you made about terrorism is an important one, which is to recognize that there are different dimensions of terrorism. There are individual acts of terrorism, and there are organized groups that use terrorism as a part of their strategy. And I think that although theoretically the same consideration should apply in each case, there are practical reasons why there's a distinction between the two. The most important of which is that, well, actually I should say two. One, there's an important distinction between foreign-based terrorism and domestic terrorism because the framework within which we think about these problems are very dramatically different. For example, the military cannot act in a law enforcement capacity in the United States, so it cannot use kinetic force in the United States. It is authorized to do so outside the United States. Many of the constitutional protections that are available either to citizens or to people in the United States are not available abroad. But I think even more important, the reason that the organized terrorism case is in some ways a different case than the individual terrorist is the fact that you have to deal with and have the opportunity to deal with a case where it's possible to develop a sustained strategy that includes not just this lethal side of terrorism, but a political side of terrorism as well. Now that, of course, applies to organized domestic groups as well as organized foreign groups. But if you're dealing with an organized group, there is a set of organized activities and a set of principles that you can attack both through trying to prevent the terrorist act, but also trying to undermine the ideology, as opposed to the Aurora-type situation, which is arguably an act of terrorism, but can't be identified in terms of a strategy. I mean, I suppose broadly in a kind of a mental health sense, but it's difficult to predict. It would be difficult to develop a strategy as to how to attack them. So I think there is a difference between dealing with organized groups which employ terrorist tactics and an individual who commit an act of terror. On the question of the state-to-state, this is clearly has been the big challenge in terms of adapting humanitarian law and the law of armed conflict to a situation which was not uncontemplated at the time of the Geneva Conventions, because we had situations of civil conflict, and the Geneva Conventions talk about what the rules are like there. But those mostly focused on civil insurgencies and not the kind of terrorist activity that we have now. And so most of the effort has been to try to develop by analogy what were the underlying ideas behind international humanitarian law and how might they apply. And it's interesting that there's been very little debate beyond the early days of the Bush administration, which tried to reject the whole idea of applying international humanitarian law to these circumstances. Even the military and the JAGs were always inclined to see these by analogy to the laws that had been developed under the Geneva Conventions, though recognizing that they had to be adapted to fit the circumstances. But there was few, except a small number who prevailed in the Bush administration, who argued that this is so outside the old paradigm that we have to do it either with a whole new set of principles or no sets of principles at all. And as I suggested, I think that in addition to the flawed legal analysis about the applicability of the Geneva Conventions, which the Supreme Court decided, I think what we came to understand was that even if that were legally available, it was a bad idea for the United States, that in the long run it would not serve our purposes in making the country more secure or advancing some of the other interests that we had.
Hello. I was wondering if you could comment on the fact that you mentioned that the pendulum has swung back a little bit from this idea that we needed warrantless wiretapping and we needed all these very broad powers for the executive branch. I was wondering if you could comment on the fact that this administration seems to have has sort of seemed to stall that swing back on the pendulum, that they've said that there are certain aspects of some of these policies that they would like to keep, and whether or not you think those are necessary or what that means for the future, things like that.
Right. Well, it's inconsistent with the Newtonian laws of physics to stall it. But if you think about it, ideally, the place where you want to be is where the pendulum is at rest and that point before it then heads up the other way. And I'd like to think, I have a few specific disagreements with where the administration is now, that the effort was to prevent it from swinging back too far. And so the places where it did swing, it obviously swung on torture. It swung on military tribunals to a point, in the sense of looking toward and getting a congressional framework for the conduct of military tribunals, but not giving it up entirely. So there was an institutional swing back there, which is to not have it done by the executive. Similarly, with respect to some of the aspects of surveillance. At the same time, there have been aspects, and obviously the most controversial, which has been the use of targeted killing. I think what's important to recognize on this, and it's a hugely controversial and difficult set of issues, is that part of this on the institutional side does reflect an institutional accommodation. That is, the administration has sought to embed its use of lethal force under the authorization of the use of military force adopted by Congress. And so it's only available to those associated with al-Qaeda, and not a broader claim of the ability to use lethal force against other threats to the United States. So in terms of the balance between the two branches, there's been more accommodation than saying that there's a commander-in-chief authority to use lethal force wherever and whenever a threat emerges to the United States. They haven't said they wouldn't, but it's certainly not an authority that the administration has claimed. So that's one accommodation that's taken place back in the pendulum swing. Where there has not been an accommodation is to involve other branches in the decision who to target. There's been a strong conviction by the administration that this has to be done by the executive branch. There's been a recognition, and you've heard a number of senior administration officials explain the very detailed process by which those decisions are made and the highly particularistic determinations that are made. But it is not one that the administration has been willing to bring the courts into, or beyond the AUMF itself, to bring Congress into as part of that decision making. So I think it is a blend. I think there is a belief by the administration that some of the elements of what was done in this preventive paradigm remains critical, that we can't fully apply the criminal justice paradigm. Some of the efforts to move the pendulum back have been thwarted by Congress. So, for example, the administration was much more inclined to try to prioritize criminal prosecutions to deal with people detained for acts of terrorism, but have found that blocked by a variety of maneuvers in Congress. I don't know whether that's now fully closed chapter or whether that could be reopened again, because I think the administration feels there is more scope. And frankly, I think it is a terrible failing in the Congress, because prior to 9/11, and indeed in the first years after 9/11, the Bush administration successfully prosecuted a number of highly placed terrorists, succeeded in getting convictions. They've been in supermax penitentiaries for a long time without any danger to the surrounding communities or other of the supposed fears that the opponents of Article III prosecutions have gone forward on. So I think there are some places where the administration would have liked to have had the pendulum swing back more. Similarly on Guantanamo, where the administration, although you can fault the tactics, and I'm among the person self-criticizing on the tactics, there's no question that the administration wanted to close Guantanamo, was prepared to move a number of the Guantanamo inmates to the United States. But that has also been blocked by the Congress. So it's a mixed bag as to what stopped the pendulum in the middle, some of it by choice, some of it by operation of other forces in the political and institutional system. There's one back over there.
Hi, how would you address concerns of strategic overcommitment in our approach to the geopolitics of oil in relation to counterterrorism efforts and doctrines such as the Wolfowitz Doctrine?
Sorry, what the Wolfowitz Doctrine? There are many Wolfowitz. Which particular Wolfowitz Doctrine?
The one espoused in '92.
If you're talking about his sort of primacy type doctrine?
Yes.
Yeah, okay.
Thank you.
Well, I think it is a concern. I mean, I do think that, my view about the strategy that, that the President and Secretary Clinton have tried to pursue, and if it's not their view, it's certainly my view of what we should be pursuing, is a recognition that although our interests are global, it's the nature of an interdependent, globalized world that we can't pretend that we don't have very significant interests abroad, and things that happen outside the United States affect us deeply. It's also true that most of these big problems we can't solve by ourselves. Almost all of the big challenges of our time, including terrorism, require the cooperation of others. And therefore, we need to build a strategy rather than based on American primacy and American unilateralism, and one that recognizes that we must have partners to be successful, and that we may have to accommodate the interests of others to get them to be our partners, but in the long run, we're still better off by being sensitive to their concerns and having them work with us than thinking that we can handle these things unilaterally. I mean, if you think about the fight against terrorism, we have done some things unilaterally, but most of the great successes have been done in cooperation with others. And whether it's their law enforcement systems, their intelligence systems, or others. So I think it is critical for us, on the one hand, not to be so concerned about overstretch or overcommitment that we excessively retreat, because I think the world will come back and bite us if we do. We just have too many stakes there. But we need a strategy that's focused on maximizing global cooperation, finding communities of interest to deal with these problems: terrorism, climate change, global public health, all of the big problems that pose the greatest threat to our long-term security, and begin to build those relationships and those habits of cooperating with others that recognize that if you want people to cooperate with you, you need to have them along. There's an old African proverb that Vice President Gore used to like to quote, which is, if you want to go fast, go alone. If you want to go far, go with others. And I think that's a pretty good model for thinking about U.S. strategy. Anybody else? Back? Hard to see back there. All right, Dean. Thank you very much. Thank you all for coming.